So this is a review of the quiz on Rule 202.16. Question 1. A signed copy of the attorney's retainer agreement with the client shall accompany the statement of net worth filed with the court, and the court shall examine the agreement to assure that it conforms to appellate division attorney conduct and disciplinary rules. Where substitution of counsel, so you fire your lawyer and you get a new lawyer, occurs after the filing with the court of the net worth statement, a signed copy of the attorney's retainer agreement shall be filed with the court within B, 10 days of its execution. 2, an RJI shall be filed with the court by the plaintiff, no later than 45 days from the date of service of the summons, unless both parties file a notice of no necessity with the court, in which event the RJI may be filed no later than 120 days from the date of service of the summons. Notwithstanding 202.6 sub A, the court shall accept an RJI that is not accompanied by other papers to be filed in court. So the answer was A, 45 days, service 120 days, and shall. Question 3. In all actions or proceedings where this section is applicable, a PC shall be ordered by the court to be held within 45 days after C, the action has been assigned to a judge. 4. An order directing a PC shall set the time and date for the conference, and shall specify papers to be exchanged. They must be exchanged no later than 10 days prior to the PC unless court directs otherwise. And they include what? Well, there's a whole list of what they include, but for this question, the answer was choice B. Statement of net worth have to be filed no later than 10 days in advance of the PC. 2 says paycheck stubs for the current calendar year, and it's also the last paycheck stub for the previous calendar year. Choice 3 is wrong because it says 5 years, and it's all filed state and federal income tax returns for the prior 3 years, not 5 years. So that was wrong. And 4 is correct. It says all W-2 and tax statements for any year in the past 3 years where the party did not file their income tax returns. So the answer was B. At the question 5, at the close of the conference, the court shall direct the parties to stipulate in writing or on the record as to all resolved issues, and the court shall so order those, and to unresolved issues, they have to specify those as well. And any issues that are not resolved and not specified may not be raised in the action unless there's good cause shown. So then basically this question was looking for a time period for the completion of discovery, and the answer was A, 6 months for a non-complex case, and that's when you would schedule a date of trial. So if this date of trial is going to be within 6 months, that means discovery has to be completed. 6, court may appoint an attorney for infant children or direct the parties to file with the court within D, 30 days of the conference, a list of suitable attorneys for children, and the court will pick one. The court shall schedule a compliance conference unless the court dispenses with it based upon a stipulation of compliance filed by the parties. Question 7, this is true. Unless court excuses their appearance, the parties have to come to court and be present during the compliance conference, and the judge shall personally address them at some time during the conference. 8. Now, if you had no idea what the answer was, you still should have guessed D, 20 days. Responses to demands for experts shall be served within 20 days following the service of such demands. So just real quick, because we haven't gone over the CPLR and discovery yet, basically there's more than one way you can get discovery. There's 7 disclosure devices that you'll see when we do like Article 31. But generally the way that it works is that if you're getting discovery from a party, you're going to serve a demand or a notice. And if you're getting discovery from a non-party who has nothing to do with the case, you're typically going to be serving a subpoena or a subpoena ducis tecum on that party, on that non-party. So the reason why it's talking about notice or response to demand, all you have to do is serve demands for information on the party, and that party has to respond within 20 days of the service of the demand. There's different rules for subpoenas which are served on non-parties. 9, each expert witness whom a party expects to call at the trial shall file with the court a written report which shall be exchanged and filed with the court no later than 60 days before trial, and reply reports 30 days. So the answer was B. Just remember, when they're talking about matrimonial action, expert witness, it's a 60-30 time rule. So 60 days before trial for the report and 30 days before trial for the reply report, if any. 10, statement of proposed disposition has to be filed with the note of issue by the party that files the note of issue. And the other party, unless they've already filed a statement of proposed disposition, has to file that within 20 days after they've been served. 11, in all actions referred to the family court by the Supreme Court, all documents, including supplemental statements and everything, shall be transmitted to the family court with the B, order of referral. 12, a notice of motion related to intermaintenance or child support shall contain a notation indicating the nature of the motion. Any such motion shall be determined within 30 days after the motion is submitted to the judge or justice for decision. So this also applies to actions in the family court that were referred by Supreme Court. The judge only has 30 days, and this was a fill in the blank. Okay, question 13 was asking true or false, and it says, upon any application, yada yada. Basically, this is false. There's 2 reasons why it's false. The way that this should read is the following. Upon any application for an award of counsel fees or fees and expenses of experts made prior to conclusion of trial, the court shall set forth on the record or in a written decision in specific detail the factors it considered and the reasons for its decision. So this is 2 reasons why I was wrong. It said after instead of prior, and it said it had to be on the record, and that's not true because it can also be in a written decision. Number 14, circle all correct answers. Except as otherwise provided, when there is no sealing order or not, the court shall redact CPI in submitting for publication written decisions or combined decisions and judgments for publication. So, and the answer was all 7 of these. The taxpayer ID number, social security number except the last 4 digits, true. 2, the actual home address of the parties and their kids, true. 3, full name of minor except their initials, true. 4, date of birth except year, true. 5, full name of either party where there's allegations of DV, neglect, or abuse, true. Full name of any party when there's allegations of mental health issues, and that's true. And this one, number 7, it was a weird one, that's why I put it in the question. The full name of either party where there are allegations of juvenile delinquency. Now, juvenile delinquency is usually a child, unless they're talking about a prior JD adjudication, then maybe they would be putting that in the papers for some reason. But anyway, just know that that's there. Juvenile delinquency.